Thank you. Good morning to everyone. This morning we're going to talk about damages in U.S. tort law. There are two main categories of damages: compensatory damages and punitive damages. So I'm going to start first discussing compensatory damages. And within compensatory damages, there are two subcategories known as economic and non-economic. So for economists, these are not very good terms because both types of losses are real losses and have real economic effects, but those are the traditional names. Sometimes you hear the words pecuniary or monetary damages versus non-pecuniary or non-monetary damages. So what are these? Economic or pecuniary damages are the main components are lost wages and medical expenses. And interesting, this is a very contemporary issue. In fact, many in the United States are only recently becoming aware of some underlying controversy in how we compute economic damages. I'm going to talk mostly, as you'll see in a minute, about controversies in our pain and suffering or non-economic damages. And many times you'll hear that economic damages are not controversial, whereas the non-economic pain and suffering are. However, there is some controversy embedded in how we calculate our economic damages. So particularly with respect to forecasts. So when someone is injured and they, for example, can no longer work, let's say they're 30 years old, and the court is having to, or the jury and the court are having to compute what the amount of those foregone wages are. So oftentimes we use these work-life tables, and this is a time during the trial where typically an economist comes in and gives his or her projections as to what the future life expectancy of the person is and their future work-life expectancy. So those two things aren't the same things. And these tables that they come in with are differentiated by gender and by race. So what's interesting is in the United States, where we have lots of disputes and controversies in our area of constitutional law, namely whether you can treat individuals differently on the basis of race or gender, and a whole set of jurisprudence suggesting that grouping people into those categories deserves heightened scrutiny and attention. There's very little attention given to the fact that we do that within our tort system. So these tables, these work-life expectancy tables, are historical tables. They're historical averages. And so, as you might imagine, any kind of discrepancies that are based on the fact, for example, that there might have been discrimination against classes of people historically that we've overcome, etc., this will be embedded in these tables. So I bring this to light. As I said, it's a very contemporary issue that we're only beginning to deal with in the United States with respect to how this affects tort damages. So tables for women, for example, while women have longer life expectancies than men, their work-life expectancies are much lower, are depressed. Why? Because in the United States, historically, women took much more time out of the workplace. It was typical that they would stop working during the period when they were raising children, for example, etc. And so today, if a woman is injured, notwithstanding the fact that maybe she was not going to repeat that historical course, these tables, which are historical tables, have that embedded. And so, for example, the damages that would be given for future expected loss of wages are going to be depressed for women versus men. With respect to African Americans in the United States, these tables are even more depressed because they include historical averages of people not only taking voluntary but involuntary time out of the workplace. So in the United States, in our history, and continuing to today, it's more likely for African American men to be out of the workforce, etc. And so I raise this because it's a kind of interesting, as yet not explored issue in the United States about a kind of about how sometimes the methodology of how we compute these future expected wage loss figures can be quite controversial. There's a recent case from a judge in New York named Jack Weinstein, who is in his 90s and still very active. He's a very well-regarded judge on the district court in the Eastern District of New York, and he had a case before him that was an appeal of, it was an African American who was injured on the Staten Island ferry. There was an accident where the ferry was responsible, they were negligent, there was a very bad injury, and this man became paraplegic, so he couldn't use his limbs. He was in very bad shape, and in the course of his trial, the economist had come in and, as is typical, had used these tables that were race-based tables on work-life expectancy. And the judge, not the lawyers, this is what was interesting. Usually the lawyers in the United States would object to various things that go on at trial. This was seen as non-controversial. So the lawyers didn't raise any issue, but the judge himself got angered at the use of these tables, and in particular said that it was unfair when considering the amount of damages to give to this individual for his future expected medical expenses as well as his future expected work-life expectancy, to use tables that were biased downwards for the very reason that on balance, African Americans got substandard medical treatment. He said where an individual's been injured through the fault of another party, we should assume that that person should get the best medical care, should be treated equally, etc. So he, in that case, decided, and the figures were pretty dramatic. If you used the figures for a white man of his age, the damage award would be much, much higher. And the judge decided that that would be the appropriate inquiry in that case. So I bring that to your attention because it's an interesting juncture at trial where the economists come in and sort of present their tables or their calculations. And we're only at the beginning, I think, of a stage where some lawyers and some law professors are interested in that kind of civil rights issue and trying to probe a little bit more deeply, maybe challenges to some of these tables. It also, by the way, before we move on, it also gets at the point that when we award damages in our tort system, they're very much individuated. And for that reason, it comes to light very dramatically that we treat different classes of people differently. And oftentimes, when you're talking about an adult who is in a particular profession and has a historical track record, let's say an individual is injured who has been working in the same job for 20 years, it's easier to do the kind of projection as to where he or she would have ended up in, say, 5-10 more years. When you're dealing with a child or a young person, how do you do those projections? So typically in the United States, the way these projections were done were just using these tables based on historical averages. And as I said, these tables are divided by gender and by race. But there's something in the United States, at least, that's jarring to some individuals because our society is premised in some sense on the idea that the children will outpace parents, right? You could come from a relatively poor background, and yet through advancement, your children could succeed in society. And yet these kinds of projections, when it comes to a child or a young person, are really using the social status of the parents and then categories like race and gender to make those projections. So it's a kind of interesting, I think, fertile area in the United States for further controversy. There's other countries, by the way, Israel and Canada come to mind, that have very important judicial decisions talking about how it's wrong to do that. So in Israel, there was a decision about damages to a young Palestinian child, and instead of using tables that would limit the future expected wages based on his or her family's social situation, the court decided that they should use national averages and the like. Okay, the next category of damages, which really is the category that has been subject to a lot of scrutiny and a lot of debate in the United States. So unlike what I was just talking about with respect to economic damages, non-economic damages have been studied for a long time. There's a raging debate about the purpose of these damages, about how you measure them, how high they should be. Lots of our tort reform lobby has criticized this category of damages and have increasingly imposed limitations on this category. So this is the category that's known as pain and suffering damages, and then in some small number of jurisdictions, in addition to pain and suffering or anguish, they will award what is called loss of enjoyment of life, or hedonic damages. Calculating pain and suffering damages, very difficult for some obvious, some maybe not obvious reasons. The majority of jurisdictions in the United States allow juries to hear what's known as the per diem method. So per diem, or by day, asks the jury to think about how much money they think would compensate for a short increment, like a day's worth of suffering. So a victim has received a horrendous back injury and is suffering chronic pain, let's say. So the jury is asked to put a dollar value on what that pain would be worth for one day. And once they can figure out that increment, then the attorney comes in and asks them to multiply that by the number of years in which this individual will be in pain. So they take that amount and they multiply it by the expected life expectancy of the individual. This is, as you can imagine, controversial. It was a tool that was invented or came up with by plaintiffs' attorneys who were trying to figure out a way to increase the amount of pain and suffering damages, because they thought if they just came forward and suggested a very large amount, so $5 million, it would look like they were just pulling that out of a hat. So the way that they tried to ground it in reality was through this pain per day. Now, it's controversial because there's been a lot of study in the United States about measurement of pain and suffering, and not surprisingly, it turns out that individuals vary quite a lot in terms of how they experience pain, as well as how they adapt to pain. So for some individuals who get an injury, the pain and suffering might be quite high in the beginning, but then over time it goes down as they adapt to their new circumstances, etc. And there are all these theories out there, people who are studying some of this, because I guess they don't want to call themselves pain and suffering as a field of study. They're called happiness studies, but these happiness studies, many of them are actually trying to come up with more precise measurements for figuring out how to quantify pain and suffering over some long period of time. And only, very recently have some of these measures been introduced at trial, and they're a bit controversial. Some jurisdictions permit the plaintiff's attorneys to include in the instructions that the judge will give to the jury something about how to calculate pain and suffering using this method. But if that happens, the jury's also instructed that this is not hard evidence, that this is just a theory. Other jurisdictions will not instruct the jury using any kind of a method. They will just say you are allowed to award some amount to compensate for the pain and suffering, the anguish, and then they let the plaintiff's lawyer in his or her argument, closing argument to the jury, suggest a possible way to calculate these damages. So as a result, there's some criticism about how the jury is given very little guidance. Some people have proposed things like, why not tell the jury? We were discussing this in one of the earlier panels when we talked about the wealth of data that we have in the United States. There are academic studies, there's research that lawyers do in cases in order to advise their clients for settlement purposes, doing kind of comparative verdicts. So you can, I mentioned in one of the panels, you can go onto an electronic legal database known as Westlaw, and you can search for jury verdicts and settlements, and you can see jury awards, how much did they give for economic damages, how much for non-economic, let's say in a burn victim case, and you could get a range of values. And by and large, it's very difficult to tell the jury directly, this is the range of values that you should use. More often what happens is we let the jury award what it thinks is fair and right for pain and suffering, and then we let the judge, when they're reviewing this award, to look at things like comparative verdicts, etc. But many people have said we shouldn't treat the jury in this manner. We should give them more direction. We should give them something to have as a baseline when they're calculating these damages. Oh, that's not good. What did I do? Okay, hedonic damages. As I mentioned, a very small number of jurisdictions will allow recovery for what's known as hedonic or value of life as a separate form of damages. So this is controversial, right? Because in the common law, when someone dies, their claims died with them. So there's no recovery under the common law for wrongful death. What we have is we have a system in our common law system where states have enacted wrongful death statutes. So all damages in the United States that are given for wrongful death are statutory damages. They used to be very limited. They used to be limited pretty solely to economic damages. They were designed so that if, say, the breadwinner, if a spouse was killed who was the primary, giving primary financial support, then the relatives could recover, the family members, the spouse could recover economic damages for the loss of the financial providing of the spouse. And those statutes have been broadened to include some amount of pain and suffering damages. Typically, what those statutes allow for, though, is just pain and suffering of the deceased, of that individual, in the moments or time before death. There's a good study that David Lebron, who was the former dean at Columbia Law School, did, where he did a study of jury awards of the pain and suffering in the moments before death, and he found that juries were giving very high awards for that pain and suffering. It might be someone was in a plane crash due to someone's negligence, and in the 5 minutes in which they were aware of that, the jury awarded a very large amount of pain and suffering. And his theory, and I think there's validity to it, was that what the jury was really doing was trying to award some amount of money for the lost value of life. The idea that someone is killed prematurely, you're killed at 30, and what's the loss there? The loss isn't the pain and suffering in the moments before death, it's the loss of the value of the rest of your life. But since the statute didn't permit for that recovery, the jury was instead making that award through pain and suffering. So a few jurisdictions are upfront about allowing for a kind of value of life. This is a fascinating topic in the United States, how you value a person's life. Sometimes people say it's impossible. Life is priceless. How could we come up with a value? There are some very good methodological studies called Value of the Statistical Life study, and how they get measurements of the value of life is they look at wage premia. They look at the amounts of money that individuals will accept to take on jobs that expose them to small increments of increasing risks of injury and then risk of death. And they try to then use this as a valuation, what the person, him or herself, values his life at with respect to these decisions that they make in terms of choosing various occupations. There's a researcher named Kip Viscusi who's done probably over the last, I'd say, 2 decades, the most work in this area, and it's fascinating to see how we do have a figure that the modern contemporary figure for value of statistical life in the United States is about $9 million. And it's interesting to look at that figure and to compare it with typical awards given by a jury, particularly a jury who's not informed in a jurisdiction of that value of statistical life. That value, by the way, is what's used by our federal agencies, like the National Highway Traffic and Safety Administration, which is known as NHTSA, which comes up with regulations. This is the ex-ante public regulator. They design regulations for car safety. Or the Environmental Protection Agency, the EPA, comes up with standards for regulating pollutants. And one of the things that we ask our public agencies to do is to do cost-benefit analysis to decide at what level should we be regulating pollutants. So what they need is they need to use some value of life in order to say, if we regulate at a more stringent level, we will save X numbers of lives. And so this is the figure that we have our federal agencies using. So one of the interesting questions is, should we have our public regulators and our private system using different pricing mechanisms? It sounds crass to say we're pricing the value of life, but in essence, in some situations, that's in effect what we are asking. We're just asking in a more vague way when we ask the jury to do this. I mentioned that there's been a lot of attention given to non-economic damages, lots of controversy about the fact that they are not based on hard evidence. You know, when it comes to the economic damages, the parties bring in medical bills, they bring in some history of wages, and then they have these tables, as I mentioned before, to project future wages. But when it comes to non-economic or pain and suffering, it's not based on the same kind of hard evidence. As a result, it's been a target of reform in the United States, and there are many jurisdictions that have enacted caps that limit the amount that a jury can award in pain and suffering. The typical way that these work, 10 states have enacted a cap on just general pain and suffering damages. Non-economic damages in all cases will be limited, and they either enact a hard cap, so some jurisdictions will say the jury can award no more than $250,000 for pain and suffering. Interestingly, these caps are not disclosed to the jury, so we have a situation where you might hear a jury awarded some huge amount in pain and suffering, and then the judge, after the fact, will say, even though the jury awarded $1 million, we cap that at $250,000. So the judge will impose the cap after the fact. So we actually have some data looking at the difference between what the jury awards and the cap. Now, you always could wonder whether the jury, remember in the United States, the jury is everyone. It's me, it's people who are not informed in the law, etc. So you can wonder whether jurors actually know something about the law, and they might act strategically. I'll come back to that in a minute. 35 states, so a majority of the jurisdictions, have capped damages only in medical malpractice cases. So I mentioned last night that there have been a variety of reforms, evidentiary reforms, or reforms requiring expert testimony in medical malpractice cases. There also has been a big movement in medical malpractice cases to cap pain and suffering awards. What are the effects of these caps? What's interesting here is this has been a rife area for study, both because there is a lot of data and many academics are interested in testing theories, in testing not only what the intended effects of caps on damages are, but what happens in practice. So the intended effect, sort of when legislatures enact these reforms, what they're trying to do is reduce plaintiffs' recovery, but the empirical research shows that what it tends to do is selectively reduce plaintiffs' recovery. So what it's done, and there's empirical evidence to back this, is that it has disproportionately affected individuals, many of whom have potentially serious injuries, but they have low economic damages. So they're people who don't fare well in the labor market. I say here like housewives. What I mean is these are women who don't work outside of the home in the workforce, right? They're going to have very low economic damages. They might have very high non-economic damages. So there's a whole set of studies that try to show this, and the kinds of injuries that have happened to these to women in particular have been very serious reproductive injuries, so things that have led to women not being able to bear children, to have long-term effects and the like. And although they could come up with very strong theories as to why they have suffered pain and suffering and anguish, etc., these caps will cap that component. Now, I told you that juries don't know about these caps. Obviously, plaintiffs' attorneys who practice in a jurisdiction know about these caps, and it affects the types of cases that they are able to take. Because if they had a case of a woman, the other class of individuals who gets affected disproportionately are the elderly, many of whom will not have large economic damages, but might have some large pain and suffering component. It will affect the plaintiff's attorney's willingness to take on those cases. So those cases might have a high probability of winning, but if the total damages expected is too low, then the attorney's not going to have enough of an incentive to take those cases. An intended effect is that these caps would reduce insurance costs. The idea was if there are lower damages, which would lead to fewer claims, then this will decrease premium rates. So it's interesting here, too. Some of the empirical studies. There was some good ones done with data from Texas. As I mentioned at one of the earlier panels, the best way to study these questions is looking not just at jury awards and verdicts, but looking at insurance closed claims data. And Texas and Florida are great jurisdictions to study these questions because all of that insurance information is publicly available. It's more difficult to study on a nationwide basis because there's not access to the same data. But there's a team of researchers doing empirical legal studies who've looked at this issue very closely in Texas, which has capped all of the medical malpractice awards, and also, as I mentioned last night, has introduced other reforms to try to decrease the amount of medical malpractice claims. The empirical studies there show that notwithstanding all this, insurance rates have not gone down in Texas. So the kind of theory as to what the intent behind these caps and the reality has been a little bit different. Caps are designed, or one of the effects of caps has been to encourage settlements further. So if damages are capped, the idea is it makes it more predictable, that the attorneys will have a better sense, that there will be less variation, there will be less of this idea that you could go to trial and you might get a very high award or a very low award, but there's a lot of variation. Caps make these award amounts easier for the attorneys to calculate, makes it more stable and predictable. And again, there's been empirical study that show that the average settlement for attorneys who are negotiating under a cap tends to be lower than the average settlement absent a cap. These, by the way, have been studied in simulations, which is quite interesting. So they've used the same, they've tried to use the same set of individuals and just vary the situation as to whether they're doing the negotiations under a cap or absent a cap, using the same factual scenarios. And the studies have shown that about less than half the amount of settlement for those negotiating under a cap versus non-cap. So it does seem to affect settlements quite dramatically by depressing the amounts of recovery. There's something that I've studied that's a little more novel, which is what I term the crossover effect. So one thing I became interested in is whether, because we're talking about juries, and we're talking about juries who have a lot of discretion to award damages, would there be an effect if you cap the non-economic component? Would there be an effect whereby the jury could be encouraged to increase the economic damages? Now, to many, that seemed fanciful, the idea being that, well, wouldn't plaintiffs' attorneys always have put in enough effort to maximize the amount of economic damages? But I began to find some evidence when I looked at this question that when plaintiffs' attorneys could rely on very high non-economic damages through their argumentation, they would devote their efforts to that. And when those got capped, they would have to devote further effort to maximizing the economics. And how did they do that? Well, they started becoming very creative and getting experts to come in and testify as to how we could take certain services that weren't valued, in the labor market and put a monetary value. So, for example, in the situation of a quote-unquote housewife, they would come in and start talking about the services provided, the cooking and cleaning and raising of children, etc., and they would quantify these costs, talk about if she were not there and had been out in the labor force, they would have had to pay various people to do these services. And I think that was an interesting, for me, lesson, I guess, in the kind of creativity and motivation of plaintiffs' attorneys when they're given certain obstacles to try to put their effort into another component of the damages. And it also opened my eyes to the idea that this category of economic damages might be more malleable than we had previously thought. And another example of this is what I told you about earlier with respect to these tables that are used to calculate economic damages. Again, if you're a plaintiff's attorney, let's say, and you're representing an African American client, and you're in a state that caps non-economic damages, you might have a lot more motivation now to challenge the kind of tables that are using that are depressing the economic damages. And I think we have started to see, and we will see more kind of scrutiny of the economic damages calculation, because the category of non-economic has now been limited in most jurisdictions. A couple of interesting things that have been studied. We have in the United States, in addition to all of the data I was talking about previously that we collect about actual jury verdicts and settlements, we also have a very robust literature from social psychologists and other social scientists that do simulations and that do massive mock studies. So they get people together and they actually they test things like, if you were a jury, what are the factors that are going to influence what kind of an award you give? So it's really fascinating research for lawyers to take advantage of, because in the United States in particular, because it shows different ways in which the jury might be manipulated in their calculations. So one effect is known as the anchoring effect, which has been studied quite a lot. And the idea is that anchoring occurs when a person's numerical judgment is going to be dramatically influenced by being given a particular number. So in other words, if you're sitting on a jury and lawyers are making various arguments based on various theories, what are the purpose of these damages, what are they supposed to be awarded for, and the like, and you're then just given one number, right? A number is suggested to you. The anchoring effect suggests, right, this is a kind of human cognitive effect, so that you will fixate on that number. In other words, if attorneys are able to suggest a particular number to the jury for damages, for pain and suffering, it's likely to be very influential. They've repeatedly been shown in the context of these jury trials, so these simulations of individuals as to how they would make their decisions. They show pretty convincingly that a plaintiff can obtain higher damages by requesting more if the jury is informed of the request. As the demands increase, it appears that the jury awards do. One of the things I want to come back to later is particularly with respect to punitive damages and trying to understand why it might be that juries seem to award these huge astronomical numbers, and that's been happening over time, is whether or not they have been, the anchoring effect has gone on, where they've heard or read about one of these previous awards, and then it just becomes something that they anchor on. Again, I want to put that in a context, because the jury's award isn't the final say on damages in our system, but it might explain what's going on in terms of understanding jury behavior. Plaintiffs, by this I mean really plaintiffs' attorneys, almost always present a concrete damage award or suggestion, demand, to the jury. And most defendants don't suggest a corresponding lower figure to the jury. So if the plaintiff's attorney has said, I think $1 million in pain and suffering, defendants very rarely will introduce a lower figure to the jury to say, I think you should award $100,000. It's interesting as to why most defense attorneys, and they've been surveyed on this question, say they fear that if they do that, juries will think that they're conceding liability. So they'd rather just say, we're not responsible at all, instead of getting into a determination of damages. There is, though, a quote-unquote credibility effect. So if the plaintiff's demand is so unreasonable, there's been a very recent study that shows that this will not only lead the jury not to give that high award, it often leads the jury to say no liability. In other words, it affects the entire credibility determination of everything the lawyer has said to the jury. Okay, I want to turn now to punitive damages, and I want to start, it's a little bit blurry over here, but this is a picture from the newspaper that says, "Jury sends message. Local woman wins $2.9 million over burning hot coffee." Okay, this is the infamous now hot coffee case. And as I mentioned on a previous panel, the name of the case is Liebeck. It was Stella Liebeck is the name of the woman versus McDonald's. This is a case that I'm going to tell you sort of the true version of the facts of this case, as well as what happened with the jury award. But before I get there, we have to acknowledge that this case became a very powerful symbol, not only in the United States, but worldwide. I think I mentioned at one of the earlier panels that I have spoken about punitive damages in many countries, and including China, Taiwan, Europe, and the like. And pretty much without fail, among groups of people who know nothing about punitive damages, who don't really understand what they are, why they're awarded, they know the McDonald's hot coffee case. It's the one case they know. It is unbelievable to me, in a sense, the kind of victory of sorts that this case represents, a kind of poster child for the tort reform or defense lobby in the United States. It powerfully seems to evoke a kind of skepticism or really horror about punitive damages, not only within the public in the United States, but even more so internationally. Now, what's unique to me about this case is that it is true that the jury awarded $2.7 million in this case, but the media reported this as, "Isn't this absurd? Here's a situation where a woman," first of all, they reported, I think, that she was driving her car through the pickup at McDonald's. She got coffee and proceeded to drive and spilled it on herself, and then came and won this huge award against McDonald's. Well, the true facts were slightly different. The true facts were that her nephew was driving, got the coffee, and then pulled into the parking lot, handed it to his aunt, who was opening it, and it did spill. Now, this wasn't a minor injury. This woman, she was a 79-year-old woman who got third-degree burns all over her pelvic area. She had 3 skin grafts. I mean, the injuries were unbelievably serious. She was hospitalized in the hospital for 8 days, and she had 2 years' worth of medical bills for treating the injuries from the operations and from the skin grafts. So it was a serious injury. It also is interesting kind of how it became this poster child for plaintiffs' attorneys and greedy plaintiffs gone amok, because Stella Liebeck actually, before she got an attorney, just wrote a letter to McDonald's saying 2 things. One, this happened to me, and I have these serious medical bills. She attached all of the medical bills that she had, and she asked McDonald's for just $20,000, which was the amount to pay for her medical bills, because she didn't have the money to pay for it. And number 2, she said that your coffee is scalding hot. It's not just hot. The fact that in 2 seconds it can cause a 3rd-degree burn when it hits skin means it's too hot. I actually wrote down, and now I forget the calculation, what the temperature was in Celsius. I'm very narrow-minded and think in Fahrenheit everywhere I go, as well as miles instead of kilometers. But let me see if I can find it. I did write down. So the temperature of their coffee was up to 88 degrees Celsius, so very hot. So she wrote this letter to McDonald's. As I said, her demand was $20,000, the amount to cover her medical bills. And McDonald's offered her $800. They said, it's your fault, and we have our coffee at a temperature that satisfies customers, and we'll give you $800. And she didn't think that was right or fair, and she had these medical bills that she needed to pay. So at that point, she went to see an attorney, and I also wrote down the amounts. I looked this up. What was interesting is her attorney then tried to settle this case with McDonald's, and the attorney offered $90,000, which McDonald's rejected. The attorney later offered, as they were about to go to trial, $300,000. There was a mediator involved helping the lawyers negotiate the case, and the mediator came up with a figure of $225,000, and McDonald's rejected that. So McDonald's seemed to think they had a very good case here, and they wanted to go to trial. So they went to trial, and at that point, the jury did award. They awarded $160,000 in medical expenses, and then that was the economic component. And then they did award $2.7 million in punitive damages. So why did they award such a large figure in punitive damages? Well, at trial it came out that McDonald's had a history of having customers alert them that they had been injured by scalding coffee. There were 700 previous instances where this had happened, and McDonald's had spent $500,000 total settling those cases. So the jury was told in this case that McDonald's would not compensate or settle with Ms. Liebeck, as well as the fact that they refused, even though they had this prior experience, to lower the temperature of their coffee. So it was held that their coffee was unreasonably dangerous and therefore defective. And the jury, as I said, not only awarded $160,000 for the economic or medical damages, but did award this $2.7 million. And it probably was to send a message. How did they come up with 2.7? That's interesting, actually, in and of itself. The plaintiff's attorney said that maybe McDonald's hasn't learned their lesson, and maybe what we should do is think about what are the total revenues that McDonald's earns. And it turned out that every day at that time, McDonald's earned 1.35 million in revenues. So the jury decided, that they were asked to by the plaintiff's attorney, but it decided to award an amount of 2 days of revenue. And that's how they got to the $2.7 million. Now, the story didn't end there, although the McDonald's coffee case, kind of known to the world, ends there. Because what happened after the jury made this award is the trial judge, the judge who was overseeing that trial, reduced the punitive damages award. And this is quite typical. The trial judge has the power and authority. Now it's a constitutional authority that we'll come to reduce the punitive damages. He reduced the award to 3 times the compensatory damages amount. So that amounted to, what is that? I wrote this down because I'm actually one of those rare lawyers who likes math, but doing it in my head during a lecture, I sometimes get it wrong. So it was $480,000. Right? So $160,000 in compensatory damages and $480,000 in punitive damages. So that was what the judge decided to do in this case, which made the award $640,000, not $2.9 million. And then both parties appealed. Ms. Liebeck appealed because her attorney thought that that was too much of a dramatic reduction. McDonald's appealed. On while the case was pending appeal, the parties settled. And it was for an undisclosed amount, but it was reported that they settled for an amount less than $600,000. So what's interesting about the McDonald's hot coffee case is that it's this poster child for everything run amok in our system, and yet the facts of this case, this actually involved a very seriously injured person. It involved a company that had refused to change its business practices, and so it's a kind of case where you might argue that we not only need to compensate serious losses, particularly medical expenses, of an individual, but also we need to deter the behavior of a corporate entity who was not responding appropriately. The other thing that the typical story leaves out is it acts as if jury awards of punitive damages are the be-all, end-all, when our whole system is designed with numerous safeguards, namely appellate review by judges, which dramatically reduce any outlier jury award. So usually that part of our system or our story is completely left out. Let's talk a little bit, though, about why punitive damages are awarded. So as I mentioned, and I'm fully aware, and as I said at the outset of my lectures, I'm not here to say that everything about the United States system is right and should not be criticized. We have lots of criticism of this component of punitive damages. My only hope is that we can be informed first as to what the purposes of these awards might be and how they are administered in the United States, and then we can have a more informed debate. So the purposes of punitive damages, it's interesting. First, you hear that they can be about moral outrage. So the idea is that it allows a community to express its abhorrence at very reprehensible actions on the part of the defendant. So the idea here is while compensatory damages are designed to compensate for losses that a particular individual suffered, it might be that defendant's behavior is so reprehensible that you want to either punish that behavior or deter that behavior, and that interest is not going to be represented in compensatory damages, right? So the idea is that we'd have this separate category of damages that would allow for a jury's expression of their moral outrage. And typically when people think, I think, of punitive damages, and particularly because its name suggests punishment, they're thinking about that kind of purpose for punitive damages. And then that raises interesting questions about why should we be doing that in the civil system? Why shouldn't we reserve that for either criminal law or some kind of public state body to be administering that kind of punishment? Historically, if you look particularly at punitive damages in early English common law cases, which were a derivation of our punitive damages in the United States, they were designed actually in certain cases to relieve pressure on the criminal justice system, and interestingly, to give injured individuals a way to avoid violent self-help, right? This comes up, there are these great old cases that have to do with individuals spitting on another or creating some kind of dignitary harm to individuals, and the idea is that compensatory damages would be non-existent in those kinds of cases, and individuals might get into brawls or duels historically, and so we need some category of damages to encapsulate that kind of a dignitary affront, let's say, and allow individuals a civilized way to come to court and handle their disputes that way. It also was the case that many of these kinds of dignitary affronts would not be handled through the criminal justice system. They were overburdened. They were dealing with more serious crimes. Some economists have talked about the way that you want to channel transactions through the market, that the idea is punitive damages serve as a way, for example, in trespass to land. if somebody comes over onto your land and has violated your rights, that if they only have to pay compensatory damages for doing so, it's as if they just have to pay you a price. And so instead of going through market transactions and asking how much do you want for your land, they can just take things and pay you for it. So economists have said punitive damages serve as what we call property rule protection, to actually force an individual not to just take something from someone else and think they can pay through a liability rule pricing for that. They have to go through market transactions. There also is just a controversial but basic idea that compensatory damages sometimes don't give adequate compensation, that there could be all sorts of reasons why compensatory damages are too limited. This actually comes up quite frequently in terms of rationales for having punitive damages in wrongful death cases. I mentioned that statutes restrict the amount of compensatory damages given in those cases. Many times the idea is that if juries could award punitive damages, that amount would actually be serving to compensate them for things like loss of a value of life or other things that are not compensated for in our system. To me, the most interesting and a very powerful rationale for punitive damages, and the one that often gets lost, at least on those who look at punitive damages from outside our system, is the strongest law and economics deterrence-based rationale for punitive damages is that they're necessary to combat under-deterrence for particular types of torts that might be under-enforced. And the economists have come up with a simple but I think very powerful formula. We saw a similar formula with loss of chance damages recovery, but this one says that punitive damages should include a multiplier, and that multiplier should equal 1 over the probability of detection. What do I mean by this? Well, imagine a defendant, let's say a defendant who's doing wrongful dumping of chemicals on the roads, right, instead of taking them to a disposal site. The idea is that, let's imagine this defendant is caught, but is only caught 1 out of every 10 times it's doing this dumping, because it does the dumping late at night, where it's stealthy activity and not likely to be detected. So if they're only caught 1 out of 10 times, or another way of thinking about that, they're only sued 1 out of 10 times, so only one plaintiff of a total of 10 who could come forward who've been injured by their activity sues them. If they pay compensatory damages only, then they will not be internalizing the full costs of all the harms. Let me change the scenario slightly. Let's say I'm a product manufacturer and I've harmed all of you. I don't know how many people are here, maybe 30, maybe 40 people are here. So 40 people have been harmed. If each of you file a lawsuit against me and I have to pay you your full compensatory damages for the amount that I have harmed you, then the argument is I will be adequately deterred. Why is that? This is based on the deterrence theory of tort law, which says, hopefully you've heard some of what I've said to this point. But so we're in that hypothetical where I've harmed all 40 of you. If each of you were to bring your lawsuit, or someone brings a class action, let's say on behalf of all of you, and I have to pay compensatory damages for the individual harms I have caused each of you, then by this argument, I will be fully deterred. What do I mean by that? I mean the product manufacturer who is thinking about how much safety to take based on future expected damages will imagine having to pay all 40 of you if I injure you due to my negligence. And so ex ante, before the fact, when I'm trying to decide should I add a particular safety mechanism to my product, and let's say it costs me $100 to do so, if that's less, $100 is less than the 40 individual harms that I will do to all of you, I will take the safety precaution, right? That's what deterrence means. But what this theory says is that compensatory damages will not fully deter in situations where only one of you will come forward and sue me. And we can talk about reasons why that might be. In the stealthy dumping example, the idea is sometimes I harm people and it's not detected. In medical malpractice, it could be I harm all of you by medical error, but for a variety of reasons, only some of you bring lawsuits. So the idea is that punitive damages could be used in order to set the deterrence amount correct. So I've harmed 40 of you, one of you sues me. What happens? Well, I should have to pay you your compensatory damages plus a punitive damages multiplier. And how do I figure out that multiplier? It's 1 over the probability of detection. The probability of detection here is 1 out of 40. So I actually have to pay 40 times the compensatory damages in order to make sure that the defendant is paying the proper amount for deterrence purposes. Now, this raises very intriguing questions that I'll come to in a minute, which is even if that's so, if the defendant should have to pay this higher amount, should it all go to one individual plaintiff, right? If all 40 of you are harmed and only one of you comes and sues me, how are we going to deal with that windfall problem or the idea that there are all these absent individuals who are in need of recovery? It's related to a rationale that I've developed in some work called the societal damages rationale. And the idea is that I believe, if this is true, that many of the jury awards that we see for huge amounts of money, and I'm talking about an individual smoker who brings a case against the tobacco company and is awarded not only millions, but can be awarded billions of dollars in punitive damages. In some of these instances, the theory is that the defendant has injured persons beyond the individual plaintiff in a case. And so the jury is, through this category of punitive damages, trying to award an amount that basically is in order to deter the defendant who has really harmed all these other individuals. Even in the McDonald's coffee case, right? The idea was there were these 700 previous examples of individuals who'd been burned by the scalding coffee. The defendant had been under-deterred, the theory would go, and needed a kind of multiplier of the punitive damages in order to be induced to lower the temperature of its coffee or to take more safety precautions. Let's look for a minute. We'll come back, as I said, to that theory, but let's look for a minute at what the statistical profile of punitive damages in the United States looks like, because it might surprise you. It surprises many people in the United States who assume that punitive damages are in every case, etc. So punitive damages are awarded in 30% of cases. Now this, you have to think about this in the following way. These are plaintiffs who win at trial and who also ask for punitive damages. So that looks like a significant percentage, but you have to keep in mind that punitive damages are only requested in 10% of cases. And again, this is based on the National Center data, which covers all of the most populous counties in the entire United States. So it's a very good comprehensive data set. So punitive damages are requested in a small number of cases, 10% of cases. And in all cases that go to trial, they're awarded in about 4% of cases. So a very low percentage of cases. But cases in which the plaintiff both had asked for punitive damages and won at trial, the number looks higher. It's 30%. So that's why punitive damages are a significant category of damages to try to understand and to study. So for example, I have some colleagues who will say punitive damages are so rare in our system, right? Notwithstanding all the attention they get, they're only in 4% of all of our cases. Why devote so much time and energy to understanding them, etc.? And I think this is one of the reasons, because they are significant in cases in which plaintiffs have asked for them and have won at trial. Here again, I'm going to divide by different case type. I think this is interesting to look at. These are the percent of cases in which punitive damages are awarded. You can see that the most important category is intentional torts, right? About 65%. Again, these are plaintiff cases where plaintiffs asked for punitive damages and won at trial. There's a very strong historic connection between punitive damages and intentional torts. If people have intentionally tried to harm an individual, many intentional torts could be prosecuted as either torts or as crimes. So if you think about things like the tort of battery, right, that could be prosecuted by the state as a crime, or you could bring it as a civil tort. So it seems it seems expected that it would be this category of intentional torts. I'm interested for my societal damages theory and this theory of under-detection at looking at these other categories. Why is that? Well, intentional torts, we might think that's the place where we'll find the real retributive punishment rationale of punitive damages, right? Those are the cases in which the jury knows this defendant did something very reprehensible, meant to harm an individual, and so should be punished. And I think that's the category where we could get into an argument about, is it appropriate to punish in the civil system? But I'm interested, probably even more, although that interests me, in a second debate, which is if punitive damages have this societal damages component, this under-deterrence, we could argue this is not about retributive punishment. This is about getting the right level, the right safety incentives on the part of the defendants. These other categories, which are of employment discrimination, fraud, and particularly products liability, really interest me. Because here's an area where typically punitive damages seem to be awarded in situations where there's a single harmed individual before the jury or the judge, but there have been numerous others who have been harmed by the same activity. And I think it's an area that it's a good area to explore this non-retributive punishment rationale for punitive damages. So as I mentioned, overall, in all cases, only 4.5% of jury and bench trials lead to punitive damages. So a very small percentage of cases have punitive damages. But this number starts looking bigger, 65.8% in intentional tort trials, and then the argument I was just saying that punitive damages are also more frequent in cases where what I'd argue the collective harm to individuals beyond the person represented in the lawsuit, such as fraud, employment discrimination, and products liability. And by the way, here too, particularly products liability, is a case where there's no intentional harm even alleged, right? It's not that the product manufacturer intended to harm individuals with the product. So the theory of punitive damages, to my mind, only makes sense, it's only justifiable if we have a non-retributive punishment rationale, something related to leading the manufacturer to have the proper incentives to take care. So that would be the non-retributive deterrence rationale that I'm talking about. Okay, let's talk a bit about the size of punitive damage. This is usually what leads to a kind of sense of horror. We could think about punitive damages as a form of American exceptionalism. And of course, to be exceptional can be very good or very bad. So typically people think that the size of punitive damages is out of control in our system. But again, when you look at the data overall, this figure, again, is very surprising to audiences in the United States, let alone elsewhere, because The median punitive damages award, so in other words, half of the punitive damages awards are above this, half are below this. The median award across cases in the United States is $64,000. That surprises a lot of people because you hear about the $2.7 million in the coffee case, the billions awarded in the single smoker cases. But those really are outlier awards looked at on the whole. There are 37% that are between $64,000 and $1 million, and 13% are $1 million or higher. So another way of looking at this pie chart is to say that all of the concern is really directed to the piece of pie represented by the 13% there, right? Those are the ones more than $1 million. That's where we'll find the blockbuster punitive damages awards. Another thing that's very interesting to look at is the ratio between punitive and compensatory damages. I'm going to come back to this. Actually, this evening, I'm going to talk about a very important seminal punitive damages case before the U.S. Supreme Court, where the U.S. Supreme Court, our constitutional court, has now set up a constitutionally mandated framework for appellate review of punitive damages. And one of the constraints that the court has put into place is a guidepost that has to do with the ratio of punitive to compensatory damages. But even before that development, states were imposing their own ratios, and juries, in fact, were awarding what looked like very small multipliers. And that's what this chart is designed to show. So 76% of the trials in which both compensatory and punitive damages were awarded. So this is the trial level, not considering the appellate level. 76% had ratios of punitive to compensatory damages of 3.1 or less. So again, the overall picture looked like the majority had a kind of low punitive to compensatory multiplier. And again, this is just the original jury or judge, typically jury, award. If we looked at these figures after appellate review, and certainly today, after the U.S. Supreme Court has imposed basically a single-digit ratio, none of those outlier awards that look like they are hundreds of and maybe even thousands of times more than the compensatory damages are upheld on appeal. But even looking just at what the juries are doing, it looks like a more moderate picture. Okay, reforms. There's a big lobbying group in the United States called the American Tort Reform Association, or ATRA, and it has been advocating for a long time for various limitations on pain and suffering awards, on punitive damages. And there have been some typical limits imposed, and then there have been some more interesting ones that I'll talk about. So there's been a large call for reform. So even though punitive damages awards are relatively infrequent, it is true that their frequency and certainly their size with respect to at least the blockbuster outliers have grown in recent years. Just this summer, to give you, I want to be fair and give you the horrifying outlier awards as well. There was a jury that awarded $23 billion, not million, $23 billion in punitive damages in a smoker case against RJR Reynolds, the tobacco company. This award stands out in my mind because I have studied punitive damages for a long time, and I'm often called upon by reporters who want to understand what's going on with these awards. I was actually at a baseball game when this award came down. My phone rang, and the reporter was just astounded, saying, well, Professor Sharkey, what do you think the likelihood that this award will hold up? And I said, as you've seen, I I think, the misperception that I give predictions often. I only give predictions with certainty when I am certain. I mentioned yesterday that I gave a prediction to the California legislature that they would get $0 in punitive damages awards over a 2-year period because punitive awards would be appealed and that would take longer. Well, I made a prediction to this reporter that there is 0% chance that that plaintiff is getting $23 billion. 0%, right? Because first the trial judge will most likely knock that award way down, and then as it goes up through the appellate process, it's very, very unlikely that anything more than a 9-to-1 ratio would survive appeal. But we do still get juries awarding these blockbuster awards. And it's interesting to think about why. I think there are a couple of reasons. One, juries can be persuaded through sort of moral outrage that certain companies have repeatedly been harming individuals and have done nothing to correct their behavior. So they're more angered and they want to punish and or deter the defendant as opposed to thinking about what kind of losses this particular plaintiff is entitled to. And secondly, I do think that there's been a kind of anchoring effect, that jurors now sitting in these trials have heard about punitive damages in the billion-dollar range, and it's just been anchoring them upwards. Now, all that said, we have various checks in place through judges reducing awards at trial, and then a whole appellate review process. The main sources of concern with punitive damages appear to be that they are unpredictable, as well as there's a concern with these astronomically large blockbuster amounts. There have been, I mentioned before that we have not only actual data from trials and settlements to look at, but we have a huge data set now of mock jury studies where what's happened is they've actually, these studies are somewhat controversial because they were funded by, initially by Exxon, the ExxonMobil Corporation, who was facing a huge punitive damages award in the oil spill, in the Exxon Valdez case. But what they did is they, although they funded these studies because they were very expensive to get all of the mock jurors in, they got leading academics in the United States, and they told these academics that there were sort of no strings attached to their research. So it's controversial because of the source of funding, but what's great about it is that there are sets and sets of these studies that were done on jury-eligible citizens to test out some theories. So these mock jury studies actually show remarkable consistency. This surprised almost everyone. People thought that if juries were asked to rate behavior or conduct on a moral reprehensibility scale. So if I were to ask each of you, I started telling you a story about a defendant and what the defendant did, that they failed to take some safety precaution or they did something else, and I were to ask you, how reprehensible is that on a scale of 1 being not so bad to 8 being egregious, awful conduct? It turns out that with these mock juror studies across various demographic categories above people they got together people who were rich, who were poor, who were African American, white, who were women, men, all these categories were studied since these were mock studies and we had all the information about the people, and everyone was remarkably consistent at saying a certain scenario is a 6. Or is a 2, or is a 4. So that's interesting, just about human nature, about how we can have consistency as to moral reprehensibility. But when it came to translating, so you think this is a 6 on the moral reprehensibility, how much would you award in punitive damages? As soon as they translated the moral reprehensibility into a dollar amount, huge unpredictability all over the map. Interestingly, right, the idea was jurors are asked to do this. They're asked Not just how egregious or reprehensible is the behavior, but then translate that into dollar amounts. And they kind of have no baseline upon which to do that translation. So what's interesting about these studies is it starts to probe where the problem might be with respect to unpredictability. A potential solution might be, why not have the jury decide on the reprehensibility scale where the blame or reprehensibility is, and then have judges give a numeric value and maybe have that based on some kind of guidelines. That's been one proposed reform. But it turns out, it's interesting, these mock jury studies which have focused on how juries assign punitive damages, maybe these apply to non-economic pain and suffering as well. And maybe we should be thinking, too, about how to guide the jury in giving those amounts. A few other reforms, some state law reforms. Some states, although as we talked about last night, the general tort standard is preponderance of the evidence for liability and compensatory damages. So you have to just show the defendant more likely than not caused the harm. For punitive damages, many states have a heightened, clear and convincing evidence standard. So it's more difficult, right? You have to show, in order to get punitive damages, by clear and convincing evidence that the defendant's conduct was reprehensible. Many states have enacted caps, sort of, punitive damages can be no higher than $300,000, let's say, or maximum ratios. Many states say punitive damages can be no higher than a 3-to-1 ratio with compensatory damages. This is, to me, the most interesting kind of reform. It's a reform that I did a whole study about, and as I mentioned on a previous panel, it took me to California to testify on this particular reform. It's called split recovery statutes. What these are, about 8 states have these, and they take a percentage of the punitive damages award and they give it to someone other than the individual plaintiff. So why are these statutes so interesting to me? Well, if you combine it with a theory of societal damages based on deterrence, the idea that, as I mentioned in my hypothetical earlier, 1 out of 40 of you whom I've harmed sues me, and I have to pay you compensatory damages plus 40 times compensatory damages for the other harmed individuals, the question arises, why should you be the recipient of all of that money that was designed to compensate for widespread societal harm? Now, these states don't exactly put into practice what I think would be the best solution, which would be to create a fund that says that other harmed individuals could come tap into that fund. Or if you can't find the other harmed individuals, if it's, say, an environmental harm case where you want to deter the defendant, use that money for some efforts to enforce better behavior on the part of the defendant, right? Something related to the type of harm that occurred in this case, with an understanding that you have to give some amount to the plaintiff and his or her attorney to induce him to be the one to come forward, right? Otherwise, why would any of you come forward and take on the hassle of a lawsuit if you could just wait and put that burden on someone else and then collect from the fund? So I think we have to think about the incentive effects of the attorneys bringing these cases forward. The other thing is that in practice, what states do is either give the money to their state treasury. I think that has problems, right? That means like a state that is in hard financial times and wants to raise money might think that that's an appropriate way to do so. I think that's not exactly an ideal way to raise revenue in a state. Several of the states, though, do something kind of in between those two. They will give money to a fund that, for example, is a fund that is used for paying plaintiffs who sue defendants who are insolvent and don't have any assets. So if someone brings forward a lawsuit and gets a judgment, but the party can't collect on the judgment because the defendant is insolvent. There's this insolvency fund. So some states put the money towards that. The interesting feature is that very few people are aware of these statutes, even in the United States. Very few people have studied them, and I think they open up an interesting possibility. The statutes differ with respect to how much of the award goes to the state or to a fund. Some say 50%, some as high as 75% going to the state. So we do have an interesting, I think, very innovative reform for thinking about how it might be in a tort lawsuit that the goal of compensating the individual plaintiff might lead to a different amount of recovery to the plaintiff versus the goal of punishing or really deterring a defendant, and how you try to decouple those two purposes in tort law, but don't do it entirely. I think the wrong answer is to say we need no punitive damages. You should just focus on the individual losses of the plaintiff before you, because I think my own view is that will lead to under-deterrence. But at the same time, if you award a multiplier in an individual case and you give all that money to the one plaintiff, you haven't really effectuated the goal of deterrence as well as you could. Okay. The final point that I'm going to make, and this is really the springboard, because tonight this is what I'm going to be talking about, one of these, a case in this line of jurisprudence, is in addition to states enacting reforms on punitive damages, we now have as part of our constitutional review, and that's only since 1996. There was this seminal case called BMW versus Gore, and in that case, it's the first case in which the U.S. Supreme Court said that it was a constitutional law issue that punitive damages, if they are awarded in such a large size that they deprive the defendant of due process of law, that's unconstitutional. And the court in this case articulated 3 guideposts. So they said lower courts on appeal, you have to look at punitive damages, and selectively they singled out the punitive damages category, not compensatory damages, and you need to look at whether they are reasonable or constitutional based on 3 guideposts. The first is, how reprehensible is the defendant's conduct? So if the defendant's conduct is extremely reprehensible, that's going to warrant a higher punitive damages award. The second is the ratio of punitive damages to compensatory damages. So the Supreme Court said that's something to look at. Interestingly, though, the court said there can be no mathematical bright line. We can't say that the limit for the ratio, as many states said, was 3-to-1 or 4-to-1. But the court has said that single-digit ratios are more likely to satisfy constitutional due process. And that has been a strong signal to our appellate courts that 9-to-1 might be the limit. So what you've seen on appeal is a dramatic stability with respect to punitive damages being reduced to no more than 9-to-1 of compensatory damages. Very rare for appellate courts to let higher ratios be withheld on appeal. And the final is to look at what are the comparable statutory penalties, fines and penalties that statutes give for similar misbehavior, and use that as a kind of metric. Now, as a preview, this is where I'm going to start tonight, so hopefully you all will be encouraged to come back, I'm going to start with a case study called State Farm Mutual Automobile Insurance versus Campbell, which is the next case in the line of U.S. Supreme Court cases on punitive damages. And what's interesting, and what I want to do tonight, hopefully through 2 case examples, is bring together a lot of the issues that we've talked about to date and show you how they play out in these two very important Supreme Court cases. So State Farm is going to lead us to a discussion about insurance bad faith, because there was an automobile accident below, and then there was a dispute between the insurance company and the insured, and this led to a punitive damages case that made some new law about further restricting punitive damages. And then, just to preview, the second case I'm going to talk about this evening is a case called Wyeth versus Levine, a case about a woman who was injured when she took an FDA-approved prescription drug. And I'm going to talk about how a very cutting-edge issue in the United States called federal preemption, how we deal with lawsuits and private regulation in an area where we have a lot of public regulation as well, namely prescription drugs and medical devices. But now I remember that we break before we come back for our discussion and debate on damages. So about 15 minutes, and then we'll return and hopefully discuss some of these damages issues. Thank you.